Hello everyone, I welcome you to this lecture in which we will try to understand difference between tort and breach of contract. Before going into this discussion, let's first know the basic features that are common to both tort and breach of contract. Firstly, tort as well as breach of contract are civil wrong, for both these wrongful acts consist in violation of a civil or private right belonging to individuals as individuals, and therefore their violation affect the individual only, unlike public wrong, which consists in violation of a public right, thereby affecting society as a whole. Secondly, being a civil wrong, both tort as well as breach of contract are governed by a civil law which provides for a civil remedy in the form of compensation. With this understanding that tort and breach of contract are civil wrong governed by civil law which provides for a civil remedy in the form of compensation. Now, let's try to understand difference between a tort and a breach of contract. Firstly, tort is a violation of right in rem, whereas breach of contract is a violation of right in persona. Now, what is right in rem and what is right in persona? Right in rem is a right which is available to a person against the world at large. It is a right which binds people at large with its corresponding duty. Example, my right to security of my person, property or reputation is my right in rem, for it imposes its corresponding duty on people at large not to cause unlawful harm to my person, property or reputation. And when such right of mine which is available to me against world at large gets violated, it is a tort. Now, what is a right in personam? Right in personam is a right which is available to a person against a determinate person or body, and in which society as a whole has no concern. In other words, right in personam is a right which binds a specific person or persons only with its corresponding duty. Example, a contractual right, that is a right created under contract, is a right in personam, for it imposes its corresponding duty only on the persons who are party to the contract, for no person outside the contract is bound by or can be bound by a contractual right, and therefore we call a contractual right a right in personam. And if a party to the contract violates such contractual right, the case is one of a breach of contract. And therefore, we say that breach of contract is a violation of a right in persona. Now, second difference is tort consists in breach of a legal duty, whereas breach of contract consists in breach of a contractual duty. Now, what is legal duty and what is contractual duty? Legal duty is a duty which is imposed on a person by law and which that person owes to the people at large. Example, my duty not to cause unlawful damage to the person, property or reputation of another is imposed on me by law and which I owe to people at large. And therefore, if I commit breach of this general duty which is imposed on me by law, then I commit a tort. Now, what is a contractual duty? Contractual duty is a duty which is imposed on a person by contract and which person owes to the other party to the contract only. In other words, a contractual duty, in case of a contractual duty is one which parties to the contract voluntarily undertake to perform and which they owe to each other. This is not a duty which is imposed on them by any external authority or law, but this is the duty which parties to the contract voluntarily undertake to perform. Example, if A agrees to sell goods to B for price, then under this contract, it is A's duty it is to transfer the goods to B, and duty of B is to pay the amount of consideration to A. Now these duties of A and B are not imposed on them by any external authority or law, but under this contract they have voluntarily undertaken these duties on them. And if either A or B fails to fulfill his duty, then which they owe to each other, then the case is one of a breach of contract. And therefore we say that a breach of contract consists in breach or violation of a contractual duty. Now, third difference is with respect to the motive. In case of breach of contract, motive for breach is immaterial. Whereas in case of tort, though motive is not an essential constituent of tort, but in certain kinds of tort, such as defamation, malicious prosecution, deceit, conspiracy, or the like, motive is taken into consideration. Now, fourth difference is with respect to the damages that are awarded in case of tort as and in case of breach of contract. In case of breach of contract, the damages awarded by the court are generally compensatory. That is to say, the economic loss resulting from the breach of contract is compensated through the amount of damages. On the other hand, in case of tort, where the tort is to the property, the damages are generally compensatory only as in case of breach of contract, but where the damage is to the person, character or feeling and the facts disclose improper motive or conduct such as fraud, malice, violence, cruelty or the like, which aggravates the injury of plaintiff. In such cases, court may award or court awards aggravated damages. Even exemplary damages to punish the defendant or to deter him in future may be awarded in cases of tort, but very rarely in case of breach of contract. Lastly, the difference is with respect to the object of law of tort and the object of law of contract. The law of tort aims at allocation or prevention of losses, whereas law of contract aims to see that the promises made under contract are fulfilled. Now we can say that despite number of similarities, tort and breach of contract are different from each other in many respects. However, it is possible that a same wrongful act constitutes tort as well as breach of contract, giving rise to a concurrent cause of action for tort as well as for breach of contract. Example: father employing a surgeon to perform surgery on his son, and the surgeon, by negligence on his part while performing surgery, causes injury to the son. In this case, surgeon owes a contractual duty to father to perform surgery on son, and at the same time he owes a legal duty to take care while performing surgery to the son. And by performing surgery negligently, he commits breach of his contractual duty as well as breach of his legal duty, giving rise to a cause of action in favor of father under law of tort and one in favor of son for tort of negligence under law of tort. In such cases, father can sue the surgeon for breach of contract and claim compensation, and son can sue the surgeon for tort of negligence and claim compensation. However, the court, in case of breach of contract, will award the compensation that would be compensatory only, that is compensating father from the loss resulting from breach of contract. On the other hand, in case of in an action for tort, the court, while determining the amount of compensation, will not only take into consideration the economic loss but also bodily pain and mental agony resulting to the son from the wrongful act of the surgeon. Now, second example is a person goes to a solicitor to seek some legal advice, and the solicitor, by giving reckless and negligent advice to the person, causes heavy financial loss to that person. In this case, a solicitor owes a contractual duty to give advice to the father, and at the same time he also owes a legal duty to take care while giving advice to that person. And by giving a reckless negligent advice, he commits breach of his contractual duty as well as breach of his legal duty, giving rise to a concurrent cause of action, one under law of tort and one under law of contract, in favor of that person who sustains financial loss due to his negligent advice. Now, in such cases, the question is, which remedy should the person affected avail? Whether it's either of the two remedies or both the remedies. Whether he can avail, should he avail a remedy under tort, or one provided for breach of contract, or can he avail both the remedies? This is one question. Now, second question is whether existence of contract would deprive the person from availing remedy under tort. Now, in this case, the decision of the court given in Coupland versus Arabian Gulf Petroleum Company throws light on these questions. In this case, court held that if the person would have had cause of action under tort, had the work been done without contract, then in such cases, existence of contract does not deprive that person from availing remedy under tort. Let's make it simple. What the court said simply is that in such cases, the person will have a choice of proceeding either under tort or for breach of contract. Whichever remedy the person finds more advantageous to him, he can avail that remedy. But certainly he cannot proceed for both the remedies under tort as well as for breach of contract. Secondly, the second case is in this respect we can take note of is Jarvis versus Moy. In this case, however, the court held that if a contract has a specific term in it which is distinct from the duty of care that is implicit in a particular kind of relationship brought into existence by that contract, then in such cases, plaintiff should depend his claim on the contract exclusively. The plaintiff in such cases must depend his claim exclusively on contract. I hope you have understood whatever we have discussed in this lecture about the difference between tort and breach of contract. Thank you.